Okay, so let's try to unpack this idea that, well, that we've all seen play out, right? You turn on the news, there's a horrific crime, and you see the state's response.
Right.
A prosecutor comes out, they're taking these intense, aggressive, really rapid steps, announcing charges, usually under this, blinding media spotlight.
Mm.
And to anyone just watching, that intensity, it looks like justice. It feels like justice.
But that's exactly what we're going to analyze for you today. Because two actions that can look completely identical on the surface can actually stem from motivations that are polar opposites.
Okay.
One is genuine emotional intelligence, which you absolutely need when you're applying the immense power of the state.
Right.
And the other is something else entirely, what we're calling overzealous prosecution.
So the mission of this deep dive then is to give you the tools to tell them apart.
Exactly. To separate what is true moral clarity, which, actually requires deep, quiet, slow thought, from just simple emotional arousal, which is the thing that demands immediate, loud action.
And our source material is incredibly clear on this point. It's not a cosmetic difference, is it?
Not at all. The distinction between these two approaches, it's the difference between stewardship of the legal system and, frankly, utter institutional recklessness.
So it all starts with that first failure of imagination.
That's where the pathology begins, yes. Overzealousness, mistakes, that burning feeling of righteous anger, that emotional arousal for actual legal and moral clarity. It makes the assumption that intensity equals truth.
Whereas emotional intelligence, it recognizes that intense emotion is absolutely there. It has to be, especially in a case with, profound victim trauma or just huge public grief.
Of course.
But it absolutely refuses to let that emotion hijack the legal judgment. It's the voice that says, I see the feelings, I acknowledge them, but the law has to remain surgical.
Let's use that analogy from our initial review because I think it frames it perfectly. Overzealousness is like the driver who floors the engine because they feel so certain, so right. They're assuming their moral compass is also, I don't know, a perfectly accurate speedometer and a proof detector.
But they're not the same thing.
They're not the same equation at all. Morality and the legal requirement of proof are two very different things.
Okay, so that brings us right into this fundamental conflict, the one that really dictates the entire trajectory of a high-stakes case. And it's this question of slowing down versus flooding the engine.
Right.
So what are the core philosophies that dictate that very first move?
We can detail them, and they are starkly different. The emotionally intelligent approach, it confronts the exact same horrifying case, an appalling, undeniable crime. And it draws a very specific conclusion based on the stakes.
And that conclusion is?
The internal monologue is, this case is horrifying, and that is exactly why I must slow down.
Right, because the consequences of getting it wrong are just too high.
Exactly. The consequences of haste are far, far worse than the discomfort of just waiting for more information. But the opposing philosophy, the overzealous one, looks at the exact same horror, the same evidence, the same victim, and it draws the immediate emotional conclusion. This case is horrifying, and that is why I must act now.
And that one choice, that initial choice of tempo, that just defines everything that follows.
Everything. The emotionally intelligent prosecutor, they understand that the intensity of the event means the stakes are higher, the political optics are immense, and so the potential for a catastrophic error has just gone up exponentially.
So what do?
So their very first act is to build institutional insulation. They build procedural guardrails. They deliberately pull back, and they scrutinize their own biases.
So if the emotionally intelligent prosecutor is building insulation, what are they insulating themselves from exactly?
Well, that takes us right to how this approach views public outrage, media pressure, and all the political optics.
Which our sources call a volatile accelerant.
And it's a powerful and, I think, a necessary metaphor. Because public outrage isn't inherently bad. Right? It's energy.
Okay.
And like any accelerant, it can do a couple of constructive things. It can illuminate facts, bring hidden information or maybe reluctant witnesses out into the light. It can mobilize resources.
And this is the big but. If that volatile accelerant is handled improperly, if it's not contained, it just becomes destructive.
Instantly destructive. It can burn evidence. It can distort fundamental risk assessment by making investigators overlook critical procedural hazards. And I think most dangerously, it causes a collapse of restraint.
And restraint is the one institutional virtue the justice system absolutely requires to function.
It's everything. So the emotionally intelligent prosecutor, they recognize that volatility and they deliberately insulate their core decision-making from it. They get that the public is processing trauma and grief and anger, and they need to express that. But the state, the institution of the prosecutor, cannot.
The state has to stay cold.
Cold, surgical, and above all else, skeptical.
But here's where the two paths just completely diverge, isn't it? The overzealous prosecutor does the absolute opposite.
The total opposite. Instead of building insulation, they absorb the public emotion, all the grief, the anger, the demand for immediate action, and they amplify it within the institution. They make that emotional energy the fuel for the prosecution.
And then they make that critical mistake. They confuse that amplification, that feeling of, powerful righteous movement for actual professional resolve.
Yes. And when you look at these historical cases we're about to go through, you see this pattern again and again, where the prosecutor adopts the mentality of the angry crowd rather than maintaining the objectivity of the investigator.
So let's play that out. Say the lead prosecutor hesitates. They say, look, we need 3 more months of forensic review, or we need to resolve this one specific contradictory piece of testimony. How does the overzealous mindset see that?
It interprets that hesitation, that completely necessary request for restraint, as cowardice. Or even worse, it interprets institutional restraint as some kind of complicity with the evil act itself.
So slowing down is seen as letting the bad guy get away.
They view the necessary cooling of emotion as the dangerous cooling of justice itself.
And the core insight from the source material here is that this amplification, it isn't courage, even though it's often praised as courage in the moment.
No, it's described very plainly and I think powerfully as emotional illiteracy with a badge.
Wow.
It's an inability to manage one's own emotional state and the state's collective emotional state when you're using this highly technical, incredibly powerful legal vehicle. It's driven by the prosecutor's own psychological need to just resolve the ambiguity of the situation.
And that drive to resolve ambiguity immediately, that leads to a logical inversion that is, well, it's truly dangerous.
Yeah.
Where the urgency of the moment becomes its own form of evidence.
Right.
Let's explore that inverse relationship between urgency and skepticism.
For the emotionally intelligent prosecutor, urgency triggers skepticism. It's a mandatory internal alarm bell. They think, okay, the more horrifying the crime and the more irreversible the potential consequence, like filing a charge that could lead to a life sentence or, God forbid, capital punishment.
The higher the evidentiary bar has to get.
It must become higher. They apply the brakes and they ask for more review.
But the overzealous prosecutor, they just abandon skepticism entirely.
Completely. They replace it with that burning sense of urgency. The feeling that something must be done right now because the public demands it or the trauma is just too deep to wait. That feeling replaces the professional requirement of proving that something can be proven under the very strict constraints of constitutional law.
And this inversion is just catastrophic, especially in these high-stakes circumstantial cases like the nobody homicides we'll get to later.
Which are almost universally driven by immense public and family pressure. And this brings us to a concept the source defines as the catastrophe of finality, or the asymmetry.
So why is rushing so dangerous here? Let's get into the mechanics.
Well, think about how the law works. Once charges are filed in a case, especially after a trial ends and there's an acquittal, the system loses all of its flexibility.
You've launched an irreversible process.
Exactly. If the defendant is acquitted, the constitutional guarantee of double jeopardy kicks in. And that means that initial speculation, that shaky theory, that gut feeling that they must be guilty, it all hardens into a permanent legal outcome.
Which is never again.
Never again. And that is the asymmetry. An acquittal means the state has fired its best shot and missed. It doesn't mean the person is innocent. It just means they can never ever be tried for that specific crime again, no matter what new evidence appears tomorrow.
So if a prosecutor rushes based on emotion, gets a flawed conviction that's later overturned, or worse, gets an acquittal because the evidence just wasn't ready.
They have permanently shielded the potential perpetrator from any future justice.
So the emotionally intelligent calculus, it recognizes this critical trade-off. What is the highest cost of waiting? It's emotional discomfort.
Right. The public is in anguish, the victim's family is suffering, and the prosecutor is facing professional criticism and a lot of political heat. That's high price, no doubt, but it is temporary.
But the cost of rushing, if the evidence isn't there, is constitutional finality. That's the irreversible error.
And the overzealous prosecutor reverses this entire calculus. They prioritize the temporary discomfort, the pressure, the impatience, their own need to resolve their professional anxiety over the irreversible constitutional consequences.
They trade the possibility of future certain justice for immediate emotional release.
Which leads us right to this critical moral and legal divide, how the system handles ambiguity. tolerating uncertainty versus demanding moral certainty as a substitute for actual proof.
Emotional intelligence is totally comfortable saying, we don't know yet.
It has to be. It tolerates ambiguity. It accepts that not knowing yet is often the most honest, the most necessary, and the most legally responsible professional position you can take. It's a moment of profound institutional maturity.
But overzealousness, just by its nature, cannot tolerate ambiguity.
It can't. It experiences uncertainty not as a simple lack of data that requires more investigation, but as a deep personal and professional failure. It's a hole the prosecutor feels they have to fill immediately.
And to escape that psychological discomfort, they set off a chain reaction.
A very predictable one. Suspicion, which should just be the starting point for an investigation, it converts immediately into accusation. And then that accusation converts immediately into concrete, irreversible action, like filing the maximum possible charges.
The feeling of I am certain replaces the labor of I must prove.
And to paper over this evidentiary weakness, the overzealous prosecutor often dresses itself in moral language. We've all heard the phrases, for the child, justice for the victim, we must send a message to this community.
And that moral language becomes a rhetorical shield.
It is. That righteousness is being used as a substitute for proof. The necessity, the feeling that someone must pay for this horrific act, is substituting for causation. The actual proof that this specific defendant did the specific act under the specific constraints of the law. It's a powerful public strategy, but it's fundamentally flawed under the Constitution.
And the core insight, the thing we really want you, the listener, to absorb here, is that moral conviction, no matter how deeply you feel it, does not, and it never will, strengthen weak evidence.
It only makes the eventual collapse of that evidence more spectacular because all the moral authority you wrap the case in goes down right along with it.
Which brings us back to that final analogy before we get into the really tough case studies.
Right. Emotional intelligence is the adult who recognizes they are too angry or too upset to drive the highly complex, high-speed vehicle of the justice system. They deliberately pull over, they wait, and they call for help.
But overzealousness.
Overzealousness is the driver who floors the accelerator because they feel right. They feel their moral certainty justifies the speed, and then when they inevitably crash, they blame the road or the victim or the judge.
They never blame their own emotional acceleration.
Never.
Okay, that sets the stage for a really hard look at reality. That was the philosophy. Now let's see what happens when that angry driver actually hits the road and crashes. We're going to look at 10 instances where urgency was catastrophically mistaken for proof, and where the justice system, as the source says, tripped over reality hard.
In these historical cases, they illustrate a very clear repeating pathology. The state allowed that volatile accelerant of public emotion to dictate strategy, and the result was years, sometimes decades, of unjust imprisonment or even death. We just see restraint collapsing over and over again.
And our first example is maybe the most famous case of this kind of emotional acceleration, the Central Park 5 case from New York in 1989.
This is truly a textbook example of overzealous prosecution that was driven by fear. I mean, the crime was horrific, the brutal assault and rape of a female jogger. And the public outrage was described by the press at the time as nuclear.
This wasn't just a local story. This was a national inferno.
It absolutely galvanized the city's entire political structure. So the prosecutorial strategy that resulted was built entirely on speed and emotion. Law enforcement and prosecutors, they leaned heavily on getting immediate convictions, and they used extremely intense interrogation methods that resulted in coerced confessions, mostly from 5 minors.
Teenagers.
Teenagers who were emotionally exhausted, they were isolated, and they were highly, highly susceptible to suggestion.
And here's the critical legal failure, isn't it? There was virtually no physical evidence tying those young men to the crime.
None. Zero. Especially when you compared it to the victim's physical injuries. But the emotional need for a quick, decisive resolution, the overwhelming pressure to placate that nuclear outrage, it just completely superseded the need for actual verifiable physical proof.
And they were convicted. They served years in prison, and the system only corrected itself because of external forces.
Exactly. It took years, and it took DNA testing and the confession of the real sole perpetrator, Matias Reyes, for the truth to come out. This is a classic example where overzealousness weaponized the trauma of the community to turn manufactured outrage into false evidence, achieving that catastrophe of finality in the process.
Okay, next, let's consider the Duke lacrosse case in North Carolina in 2006. The source calls this one a masterclass in prosecutorial self-destruction.
And it really was, and it was driven purely by political optics and ego. The specifics of the prosecutor's conduct, a man named Mike Nafong, are just essential to understanding the pathology.
He didn't wait for the evidence.
Not at all. He publicly declared the students guilty almost immediately. The actual investigation became secondary to the narrative he had already announced to the world. And it's key to remember he was running for election, and this case was his platform.
So the urgency of his political situation just completely replaced skepticism.
It did. And not only did he rush to charge, but it was later revealed that he deliberately hid exculpatory DNA evidence.
Evidence that pointed away from the accused.
Clearly away from them. So this was no longer just, emotional illiteracy. This was intentional manipulation to maintain a narrative that was driven by public anger.
And the consequence was?
A total and absolute collapse of the case.
Yeah.
The charges were dismissed, and Nafong was disbarred and ultimately found in criminal contempt. The justice system face-planted on national television because the person holding the reins chose political expediency over the painstaking pursuit of truth.
Our third case is the West Memphis 3 in Arkansas, 1993, and this one highlights how these generalized social fears, what was termed moral panic plus satanic ritual hysteria, can manufacture the need for a villain.
Right, so you have 3 8-year-old boys who were brutally murdered, the community's demanding answers, and investigators and prosecutors look toward 3 teenagers, Damian Eccles, Jason Baldwin, and Jesse Miskelly, who, they dressed in black and they listened to heavy metal music.
They fit the community's idea of different.
They did. And the facts here are just damningly simple. There was no physical evidence whatsoever linking those teenagers to the crime scene. None. Their convictions relied on forced or unreliable testimony and this cultural narrative of satanic worship that was just rampant in the media at the time.
So emotion filled the evidentiary vacuum.
Completely. Because the perceived crime was so bizarre, so incomprehensible, the law just abandoned facts and followed feelings. The feeling that these 3 suspicious outsiders must have done it.
And it took years.
It took years of external pressure and new forensic evidence, including DNA that excluded them, for them to be released after decades of imprisonment. It's a tragic story.
Okay, let's talk about the gravest consequence of this pathology. The most extreme example of the catastrophe of finality. This is the case of Cameron Todd Willingham in Texas, 1991.
And this one demonstrates what overzealousness looks like when it leads directly to state-sanctioned death.
Willingham was executed in 2004 for the arson murder of his 3 young children. And the entire case relied exclusively on what was called fire science at the time.
Which we now know was basically junk science. It was based on assumptions that have since been overwhelmingly proven to be false things, like puddle burns or the color of the smoke being used to prove that an accelerant was deliberately used.
These were methods based on folklore, not physics.
Right. And crucially, expert doubts, even within the forensic community at the time, were just dismissed. They were inconvenient to the narrative of his guilt, the certainty that the prosecutor had already established.
And he was executed anyway.
He was. And the overwhelming evidence gathered posthumously by legitimate fire science experts strongly suggests his innocence. The dark lesson here is that overzealousness, fueled by moral certainty and the rush to punish, cut corners that resulted in the irreversible death of an innocent man. And once that constitutional finality is achieved, the system just moves on. It leaves the mistake behind.
Another stark example of prosecutorial ego overriding necessary restraint is the Michael Morton case, also in Texas, from 1987.
Right. Morton was convicted of murdering his wife. And the horrific reality that emerged years later during his exoneration proceedings was that the prosecutor, rather than seeking the truth, actively suppressed crucial exculpatory evidence.
Specifically, what did he suppress?
He failed to disclose police notes that described a green van seen near the murder scene, and he suppressed testimony that pointed directly to another suspect.
This was a deliberate choice, then?
A deliberate choice. The prosecutor prioritized his own certainty, his conviction that Morton was the man over his professional obligation to disclose favorable evidence to the defense.
And Morton served how long?
Decades in prison. He was exonerated by DNA, and the disgraced prosecutor, Ken Anderson, eventually pleaded guilty to criminal contempt and served time in jail.
The insight here is just so critical. The state didn't need more action or more emotion in that moment. It needed professional restraint, and it needed adherence to due process.
But instead, it chose ego and certainty.
Yeah.
And it achieved finality for the wrong man.
Okay, let's look at a case involving the power of coercive interrogation. The Norfolk Four in Virginia, 1997. Here we have four Navy sailors who were convicted of rape and murder.
And their convictions were based almost entirely on confessions that were extracted under intense psychological pressure by investigators who were just eager to close this horrific case. This is a common artifact of an emotionally accelerated, overzealous investigation.
And the scientific evidence.
It quickly contradicted the confessions. DNA evidence excluded all four of the sailors from the primary crime scene. Yet, prosecutors, having already invested their certainty and their political capital, they still pushed forward with the cases.
So once the prosecutor decides the ending, once they identify the guilty parties and announce it, the physical evidence that disagrees with that just becomes a nuisance.
It becomes a nuisance to be minimized or ignored, not a fact that demands a full halt to the proceedings. The real perpetrator was only identified later, but the institutional stubbornness meant four innocent men spent years in prison because the state refused to admit its initial rush was wrong.
And to understand the historical depth of this problem, we have to look at the Scottsboro Boys case in Alabama in 1931. This is the ultimate historical precedent for how speed corrupts justice.
It really is. You have 9 black teenagers accused of raping 2 white women. The emotional temperature of the community was volcanic. The trials were held under overwhelming mob pressure, and they happened in a matter of days.
And the evidence?
Virtually no meaningful evidence. In fact, medical testimony later contradicted the claims of assault entirely. Yet the jury convicted them, propelled by the outrage and fear of the surrounding crowd. Their lives were utterly destroyed, even though the convictions were later overturned by the Supreme Court.
And the takeaway is chillingly timeless, isn't it?
It is. Speed and mob pressure have always been the enemy of justice. Mandatory slowness was required, and mandatory slowness was completely rejected.
Now we look at Juan Rivera in Illinois, 1992, which demonstrates this institutional refusal to admit error even when you're faced with overwhelming facts. This is the ultimate failure of self-correction.
Right. So Rivera was convicted of rape and murder, and DNA analysis excluded him not once, not twice, but 3 separate times over the course of his appeals and retrials.
3 times.
3 times.
Yeah.
Yet prosecutors, having already invested their certainty in the state's resources into maintaining the conviction, kept retrying him anyway. They refused to let the case go.
So despite the biological exclusion, he was convicted again.
He was. It took 20 years before he was finally exonerated. This wasn't just overzealous action at the start. This was institutional entrenchment. They preferred defending the integrity of the initial flawed process, the reputation of their office, over defending the integrity of the facts, and over the constitutional rights of the accused.
Okay, a case defined by absolute mass hysteria is the McMartin preschool case in California during the 1980s. This shows emotional contagion overriding the law itself, all in the name of protecting children.
This became the largest child abuse prosecution in U.S. history, and it was entirely fueled by fear, sensational media coverage, and unreliable interviews with very suggestible children. The prosecution was relentless. It lasted for 7 years of trials.
And the evidence that defined the collapse.
Critically, there was 0 physical evidence, 0 medical evidence, 0 forensic evidence ever produced that corroborated the claims. The entire prosecution was a product of emotional contagion masquerading as necessary child protection.
The law essentially forgot how evidence works.
It did, because the moral panic was just too loud, too righteous, and too politically dangerous to ignore. The final outcome: 0 convictions, but millions spent, lives ruined, and institutional credibility severely damaged.
And finally, we turn to the international stage with the case of Amanda Knox. This shows this is a global pathology, not something unique to the U.S. system. This was in Italy in 2007.
Yes. She and her former boyfriend were accused of the murder of her roommate, Meredith Kircher. And Italian prosecutors, under intense domestic and international scrutiny, constructed this highly compelling, very dramatic narrative of guilt. And they often ignored contradictory forensic evidence and created a circus-like atmosphere.
They publicly demonized the accused.
They did. They created a conviction based on a compelling, easily digestible story, that whole Foxy-Noxy narrative, rather than on concrete, uncontestable proof. The case resulted in multiple spectacular overturns by higher courts and eventually led to sanctions against the prosecutors involved for deficiencies in the investigation.
So the mistake is identical across borders.
It's conviction by story, not conviction by proof. The emotional accelerator took priority over the forensic facts.
So when you look across those 10 devastating examples, the pattern is just. It's undeniable. The source identifies it so clearly. emotional intensity accelerates decisions.
And skepticism is treated as moral weakness. The prosecutor identifies with the crowd, becoming part of the angry mob, and that catastrophe of finality is achieved, locking in the state's error.
To summarize the core difference one last time before we transition,
Emotional intelligence would advise, if this case makes me feel certain, I should immediately become more suspicious of myself and my process. Whereas overzealousness says, if this case makes me feel certain, that certainty is proof enough. And only the skeptical strategy survives contact with reality.
so we understand the historical pattern, we understand the deadly mistakes of the past. Now let's shift focus, because this pathology, it hasn't vanished. It has simply evolved into modern, often highly technical, legal tactics.
Right.
So we're going to look at how this emotional drive manifests today, frequently through maneuvers like overcharging, novel legal theories, and what's called due process compression, with public outrage still driving the scope of the action.
We're transitioning now from those historical injustices, where the failure was often suppressing evidence or relying on junk science, to modern, highly politicized or highly publicized cases, where the failure lies in maximizing the law itself to achieve that emotional goal of immediate and complete systemic victory.
So we're seeing charge stacking and maximalism used as strategic weapons.
Exactly.
And our first modern tactic addresses charge inflation and novel legal theories. Specifically, we're looking at the New York business records case involving Donald Trump.
And the source analyzes this strictly through the lens of prosecutorial technique and the emotional motivation behind it. The core criticism of overzealousness here is procedural. It's about taking what was analyzed as a collection of misdemeanor bookkeeping offenses, which are typically very low-stakes crimes, and elevating them to 34 separate felony counts.
How is that achieved? It wasn't by identifying 34 unique catastrophic crimes, was it?
No, it was by stacking identical acts, and critically, by relying on an unidentified secondary crime, an underlying election finance violation, to justify the felony status of the primary acts. The legal theory itself was novel, it was untested, and it was highly complex.
And this illustrates the overzealous mindset perfectly.
It does. The question the emotionally intelligent prosecutor asks is this charge proportional to the actual proven offense? But the overzealous approach, driven by this immense desire to meet the public and political demand for a criminal conviction, asks a different, and I would say more damaging question. Can we make the charge louder? Can we force a narrative gravity by sheer volume and complexity? The result is charge inflation used as a tool of emotional and political leverage.
Okay, next, a tragic, very immediate case study in what's called evidentiary implosion, Alec Baldwin and the Rust shooting in New Mexico.
This case is a perfect modern illustration of public outrage setting the entire tempo, completely ignoring evidentiary readiness. A death occurred on a movie set, and the public and political demand for immediate accountability was overwhelming.
And the prosecutors responded by charging involuntary manslaughter almost immediately.
Almost immediately. And, crucially, they charged manslaughter before key forensic questions were resolved. Was the gun modified? Was it even possible for the gun to fire without the trigger being pulled? Who was responsible for the safety checks on set? These are necessary elements of proving criminal negligence. You have to know them.
And the outcome was just chaos.
Total chaos. The initial charges were dropped, then they were refiled, then they were redropped. Prosecutors were removed from the case due to ethical and procedural failures. It was, as the source describes it, justice flailing, just characterized by erratic, reactive movement.
The emotional urgency for an immediate finding of fault completely overrode the meticulous steps required to prove criminal negligence beyond a reasonable doubt.
That's it, exactly.
Okay. Our third modern tactic involves maximalism and process as punishment, and we're looking at the ongoing Young Thug Arco case in Georgia.
This case really highlights the broad application of the Racketeer Influenced and Corrupt Organizations Act, or ICO. For listeners who might not be familiar, ICO was designed to dismantle large-scale, enterprise-level organized crime, like the mafia, by connecting a pattern of activity over time.
But applying it to a rap collective, that risks collapsing the case into guilt by association, doesn't it?
It does. It risks catching a vast network of people under one maximal charge, far beyond the scope of a traditional conspiracy. And what's particularly controversial here, and a hallmark of overzealousness, is the introduction of lyrics and artistic expression as evidence of criminal intent.
So the state is taking art rap lyrics and treating them as literal confessions.
Or a roadmap to a criminal enterprise. And this tactic dramatically broadens the scope of culpability far beyond traditional bounds. And because the charge is so maximal, I mean, RICO cases are designed to take years, the process itself has become punitive.
Right. The trial has dragged on with repeated controversies.
So when the charge is inflated to the highest possible and broadest application, the process becomes the punishment, regardless of what the eventual verdict is.
Next, we see a fascinating flip of roles, but it's the same underlying emotional pathology. The rapid prosecution of police officers by Baltimore State's Attorney Marilyn Mosby following Freddie Gray's death in 2015.
Mosby rapidly charged 6 police officers, and she was responding immediately to immense local outrage and pressure following Gray's death in police custody. She made these very high-profile statements about achieving justice.
But she proceeded with what was a palpably weak evidentiary foundation.
Very weak. She was relying heavily on untested or ambiguous evidence regarding the causation of the fatal injuries. And the predictable outcome was that all the cases subsequently collapsed or resulted in acquittals.
So the emotional need for immediate accountability for the community entirely superseded the evidentiary requirement.
Completely. The system achieved a kind of emotional release, but no legal certainty. And the source notes the bitter irony here. Mosby later faced her own federal prosecution, which critics argue also involved charge stacking and aggressive theory building.
So the disease of overzealousness manifests regardless of who you're prosecuting.
Exactly. It's a pathology of power driven by emotion, not a specific political leaning.
Okay, case 5 is the Kyle Rittenhouse case in Wisconsin, which is a powerful demonstration of how outrage prosecution can be narrowly corrected by a jury, but not by the charging process itself.
Right. So prosecutors brought homicide charges, despite what the source notes were, overwhelming self-defense indicators that were present in the video and witness evidence.
Rittenhouse was attempting to flee, and the shooting occurred after he was intact.
Exactly. Furthermore, there were significant claims that exculpatory evidence was withheld or presented misleadingly. This was textbook outrage prosecution. The decision to charge was driven by the political and emotional need to charge someone for the deaths that occurred during civil unrest, rather than a dispassionate look at the clear law of self-defense.
And the jury's acquittal on all counts
Restored sanity to the case by adhering strictly to the legal burden of proof. But the source points out that this was luck. The system was saved by the jury's skepticism, not by the prosecutor's initial, emotionally driven charging decision.
The Adnan Syed case in Maryland, popularized by the Serial podcast, is a powerful contemporary example of what is called the aftershock problem.
Yes. Syed's initial conviction relied heavily on shaky and now discredited witness testimony and unreliable cell tower data. And years later, after intense scrutiny, prosecutorial suppression of exculpatory evidence that pointed away from him, was finally acknowledged and his conviction was vacated.
And this shows the extreme difficulty of course correction once that initial emotional acceleration has set the system in motion.
It's so hard to undo. Once that narrative hardens, once the public narrative demands a specific outcome, correcting the conviction, even when justice clearly requires it, becomes, and this is a quote, politically dangerous for the officials involved. The fear of public outcry prevents the admission of the initial error, and that just perpetuates the injustice.
Now let's look at the January 6 defendants in the federal cases as a broad category study of modern maximalism and scope creep, driven by the symbolism of the event.
Right. And again, the issue here is not about the innocence of all defendants, many clearly committed severe crimes, but it's about the tactics used by the state.
Okay.
This included the broad and aggressive use of obstruction statutes, specifically 18 U.S.C. Section 1512c2, which the Supreme Court later narrowed significantly, challenging the fundamental scope of many of the charges.
That's a classic overzealous maneuver.
It is. There was also heavy pretrial detention and extensive charge stacking used not just to win, but to increase leverage in plea negotiations. The insight is critical. The punishment is often driven by symbolism, the need to send a broad political message about the event, rather than purely individualized conduct and proportional charges for each specific defendant.
Our 8th example is the Jussie Smollett case in Illinois, which demonstrates what happens when the system swings wildly between emotional extremes and political appeasement, completely lacking emotional intelligence in either direction.
Right. This case was initially about an alleged fake hate crime, and prosecutors initially dropped the charges amid significant public backlash and criticism over what was perceived as a soft punishment for a celebrity. They were essentially appeasing a different emotional constituency.
But the system's answer to that outrage,
The backlash against leniency, was to appoint a special prosecutor who then refile the charges aggressively, seeking retribution and maximal punishment. The case later suffered multiple procedural overturns. Emotional intelligence was absent both times. First, in the chaotic decision to appease the initial defendant, and second, in the subsequent aggressive pursuit of retribution.
Next, the McCloskey's case in Missouri, where the charges were widely viewed by critics as political message enforcement driven by intense political heat.
Felony charges were brought against the couple after that gun-brandishing incident during the racial justice protests. They claimed they were defending their property. The prosecutor brought charges despite evidence suggesting they were legally possessing the weapons on their own property and didn't fire any shots at people.
So the view taken by the source is that the prosecution felt less like a measured pursuit of criminal justice,
And more like an attempt at message enforcement or political signaling, a direct consequence of the immense political heat surrounding the incident. When emotion drives the charging decision, proportionality is lost. Predictably, the case ultimately collapsed under political scrutiny and was later pardoned by the governor, which just highlights the initial overreach.
And finally, we return to the highest stakes category where this pattern of overzealousness is still actively dangerous. No body homicide cases, like that of Oakley Carlson, which is still sadly unfolding in Washington state.
And the source uses this as a final immediate warning. Prosecutors are publicly signaling homicide charges without a body, sometimes even making statements about the parent's guilt, under what is enormous emotional pressure from the community that is desperately searching for the child and for closure.
And the reiteration of the core argument is so vital here because of double jeopardy.
Right. Prosecutors often only have one shot to get the case right. The risk is not doing nothing and waiting for certainty. The risk is doing something irreversible, filing those charges based on emotion, triggering the double jeopardy clock too early before all the proof is secured.
It's trading certainty for immediate emotional relief and risking constitutional finality on a potentially unprovable case.
Precisely.
So this exhaustive journey through 20 examples, historical and modern, it allows us to summarize the through line, doesn't it? The consistent pathology that defines overzealousness, regardless of the era or the political environment.
It does. We've seen the same 4 or 5 habits repeat themselves every single time the state confuses emotional intensity with ethical maturity. And they are insidious habits.
First, we see overcharging and charge stacking routinely replace slow, methodical investigation.
Right. The prosecutor uses the sheer volume of charges to exert leverage, hoping to force a plea rather than actually prove the case at trial.
Second, public signaling and these high-profile press conferences consistently precede genuine evidentiary readiness.
The narrative gets released before the facts are solidified. And that hardens public perception, and it makes any later course correction politically impossible.
Third, the process itself. The long, grueling nature of maximalist trials like the RISC cases, it becomes the punishment, regardless of the eventual outcome.
The defendant is ruined financially and personally simply by being dragged through a process that's designed to be maximally punitive.
And finally, constitutional finality, the ultimate mechanism of the justice system, is repeatedly ignored at the charging stage until it's weaponized against the wrongfully charged defendant via double jeopardy, locking in the state's initial emotionally accelerated error.
And the distinction remains absolute, even when the facts are grim. Emotionally intelligent prosecution is defined by skepticism. It slows down when the crowd speeds up, because it recognizes that skepticism is the only reliable guardrail against institutional capture by public passion.
An overzealous prosecution does the opposite. It mistakes urgency for righteousness, volume for legal validity, and emotional consensus for factual proof. And this is where we circle back to the quiet horror beneath all of this, because it's easy to assign blame to a villain.
And that quiet horror is the inconvenient truth that allows this cycle to perpetuate. The justice system doesn't need external bad actors or outright corruption to fail repeatedly and catastrophically.
No. What the system actually needs to fail is something much more subtle and insidious.
It only needs tired prosecutors who confuse moral certainty with legal sufficiency.
They aren't villains in their own minds.
Not at all. Every single one of those prosecutors in the cases we discussed, particularly those facing horrific crimes like the Willingham case or the Central Park Five, they thought they were doing the right thing. They believed their profound moral clarity justified their procedural shortcut, their evidentiary overreach, or their suppression of inconvenient facts.
And that is why moral certainty is not a safeguard in the law. It is, in fact, the greatest liability.
It creates a system that believes it is fundamentally virtuous while simultaneously cutting corners corners that, once the irreversible legal outcome has been set, can never be uncut.
That's a heavy and I think essential thought to leave with. We have to acknowledge the complexity and the necessary difficulty of maintaining professional skepticism when the tide of public grief and outrage is pulling you and the entire institutional apparatus toward immediate action.
So if the consistent pattern is that emotion accelerates decisions and overrides skepticism, then the problem isn't about individual morality. It's about institutional design.
Right?
So here is a provocative closing thought for you, the learner, to mull over. If constitutional finality is the highest stakes outcome, what specific structural or procedural safeguards, not merely moral injunctions, would be needed to force constitutional finality to absolutely outweigh public impatience?
That's a fascinating question. For instance, should we require mandatory judicial review of evidentiary sufficiency before any charge triggering constitutional finality, like a homicide charge, can even be filed?
Or maybe mandate an institutional cooling-off period, perhaps 60 days, between the completion of a primary police investigation and the official charging decision, unless there's an active flight risk.
Where do we need to build mandatory slowness into the system to guarantee that skepticism survives?
The system that is designed to break, not just accelerate. Food for thought as we close this deep dive.